What happens when an unstoppable force meets an immovable object? Litigation. Hello, my name is Matthew Leffler, and I am the armchair attorney. I'm here to talk about a case that some friends brought up to me yesterday. DAT versus Convoy. Dial-a-truck versus the digital freight broker. This case caught a lot of media attention in 2022, but in 2023, there's not a lot to talk about. Or is there? Let's start off with the background. Convoy entered into a contract with DAT. DAT was going to provide them the services that DAT provides. For those of you that aren't in the freight and technology space, let's give a little background. DAT is a load board, the largest load board in North America. It's where trucking companies, motor carriers, find freight, where freight brokers find loads, and where shippers put things to get moved. It's a place where people are trying to make deals on moving freight. Been going on for a long time. DAT stands for dial-a-truck. In the old days, you'd go to a travel stop and you'd see the loads that might be available for you to move. And that's how you'd get home or get to the next destination as a way to find loads. What's Convoy? Convoy is a two-sided marketplace. It's an app. On the one side is shippers, on the other side are motor carriers. And they find a way to connect these two parties. The reality, though, is that's hard to do. And so you start figuring out you maybe need some access to brokers. You maybe need access to more trucking capacity outside of what you can find with your application. That's the background of how DAT and Convoy got together. Well, there's a couple little nuances, and we won't go through all of those nuances, but it's important for you to understand what they all mean. So to begin with, Dial-a-Truck DAT has a contract with Convoy. In that contract, there are things that catch your attention. One of those things is a non-competition agreement. Ooh, you know that I love talking about non-competition agreements. The non-competition agreement, specifically at issue in this, is the prohibition from Convoy to make a competing product to DAT, a product for brokers, or something that helps facilitate like load matching, load boards. And Convoy agrees in the contract. There's also an idea on pricing. DAT is exclusive for Convoy in the initial contract, and because it's exclusive, there is a discount that DAT provides to Convoy. Well, long story short, Convoy makes a product that allegedly competes with DAT. DAT doesn't like that, so DAT sues in federal court. Now, the question you might say is, why do they go to federal court? Well, this is about civil procedure. We're not going to get into civil procedure. Suffice it to say, you have to have some good reason to be in federal court, whether there's a subject matter question of federal law, or perhaps there's a diversity of the people who are being in the litigation. So different places of business, different places of incorporation, and there's some question about where you go to court. Federal courts are generally nicer, and what I like about federal courts is all of the documentation is available online for anyone who's a lawyer or people who have access to Pacer can review. There's a nominal fee to review the pleadings, but that's okay. I did that for you. So DAT sues. Convoy counterclaims. So what DAT says essentially is, hey, you breached the contract that you had with me. Stop doing that thing you said you weren't going to do. And what does DAT want? They want them to stop doing the thing that DAT thinks they're not supposed to do. Convoy, for their part, says, well, we think that you actually are anti-competitive. We think you're kind of like a monopoly. You make all these rules against us, and you do a disservice to the overall community of transportation professionals. That is the background of the counterclaim that Convoy makes against DAT. And there was a lot of paperwork flying around. I'll throw some of the links up here if people want to read the pleadings, but here are the real meat and potatoes. What Convoy was paying for with DAT initially was $47,500 per month. That is the discounted rate for being exclusive to DAT. When Convoy decided to go to other providers, that fee that they were given went from $47,500 to $52,500. This is the pricing discrimination or the pricing component that Convoy is very adamant about. We are being penalized for using other providers. The other part is the non-competition ability, the ability to say, you're not going to go out and do this. Now, many of you might be surprised about my opinion on non-competition agreement as it relates to business-to-business transactions. Fundamentally, business-to-business transactions are different than consumers or individuals to businesses. Both businesses are highly sophisticated entities that have the ability to hire the best lawyers in the world to review the contracts that are in front of them. And they know, generally speaking, what they're getting into. So I'm not the guy who's going to be screaming about anti-competition things in business-to-business deals, though I do find them interesting. What is really interesting, what's really, really interesting, is what happened. Where it happened. We were seeing all this information in 2022, but what's going on in 2023? I would submit an awful lot. Now, when you're in these types of litigation, what you're doing generally is trying to say, okay, what is it going to take to make this go away? What makes you happy? What makes me happy? Is there a zone that both of us can say we are equally or at least somewhat agreed on equal misery we can find? What is the path to a settlement agreement? I have no inside information about Convoy or DAT at all, but you can see by the pleadings that there has been something going on since December of 2022. That's the last thing that was filed in the DAT and Convoy case, which tells me we are either looking at mediation, perhaps going on right now, maybe arbitration, people talking and trying to make a deal, or simply just back and forth. What is it going to make or take to get us to be aligned on resolving this issue? Now, I was very vocal about this case when I first saw it because the way Convoy positioned this fee of the $47,000 going to $52,000 was, I felt, not really genuine in terms of the penalty that they were encountering. And DAT, for their part, has said, look, we know that we make people sign these anti-competition agreements. We've been doing this part of our business. And it doesn't mean people can't go out and make these things. We're just not going to help you do it. We're not going to give you access to all of our tools, and then you can learn about them and make your own thing. But here's the real caveat. DAT has massive market share, substantial market share. But there's new load boards popping up every couple of years. So to think that they have gotten themselves so insulated and built such a strong moat might not be real, might not be a really good claim. So when you have claims that aren't super great, you look to settle. And I think over the next few weeks, few months, we may in fact see a settlement. So the question people ask me, hey, what's going on with DAT and Convoy? Not a lot publicly, probably an awful lot privately. And we will see, as we monitor the Pacer account, if we see a settlement agreement that is somewhat viewable from our side, or perhaps simply a dismissal saying that they have agreed on some resolution. If they don't, there is massive discovery that is going on. Both companies are asking for information about who had access to the materials that DAT gave them and what things Convoy did when they made their product Convoy for brokers. I hope this 9-minute video, which we're wrapping up right now, helps you understand a little bit more about the DAT and the Convoy litigation. Again, DAT gets agreement with Convoy, tells Convoy, don't make a competing product, and if you use us exclusively, we'll give you a discount. Convoy makes allegedly a competing product, DAT sues, and then Convoy counterclaims saying, you're a monopoly, you're anti-competitive, this isn't fair. And now we have the waiting game. And everybody knows lawyers love waiting games.